Shainul Kassam from Fortune Law. So I'm going to tell you about the things that you need to know about a settlement agreement as an employer or an employee that will save you time, money and stress. So the first thing, what is a settlement agreement? So a settlement agreement is essentially a contract between an employer and an employee setting out the terms on which that employee is going to leave the business. So the benefit for the employee is that they're going to get some compensation. They may get an agreed reference, and there may be other benefits in there that they would be entitled to. For example, they quite like to leave on terms which are confidential. For an employer, they will be able to benefit from the employee waiving claims against the employer, whether or not they exist, but just to be certain. And sometimes they do exist, and an employer will be paying a certain amount of money in order for those claims to simply go away. And the employer will also benefit from confidentiality undertakings given by the employee. So why do you need a lawyer? Well, a settlement agreement, in order for it to be legally binding, requires the employee to take independent legal advice, and for that lawyer to provide a certificate to say that they understand that the employee has claims and what claims that they're waiving, and that they have given the employee sensible, adequate legal advice so the employee knows exactly what they are signing. Now, in certain situations, you don't need a settlement agreement or go and get independent legal advice if you're an employee. But that's when both parties use the ACAS service, and ACAS use a different type of agreement to settle claims, and it's called a COT3 agreement. And some employers don't like to use that agreement because it's not very comprehensive, and they want to make sure all their bases are covered. And often they are able to resolve disputes internally with no need to go and speak with ACAS. Legal fees. An employer will contribute to an employee's legal fees because an employee is required to take that legal advice. So the best way to save time and money is for an employer to actually look at the situation carefully and understand whether or not this is a senior employee, and there are lots and lots of different benefits and parts of the contract that require sensible review, restricted covenants, what the types of the claim are, and whether or not the employee has shares, for example, or is entitled to other things which will require review by a solicitor. So a sensible employer will make sensible provision. What claims are being waived? Now, an employee may look at a settlement agreement and find an entire raft of employment claims are being waived. That's usually because employers use a standard template document for the most part, and that agreement actually has all the claims that one could think of included. Employers don't want to take a risk and end up in a situation where a claim has been left out. So if you're an employee, you shouldn't worry too much about the claims that are listed, because there will be a whole list of them, and most of them actually won't be relevant to you. What's important is that your solicitor understands what has happened, what your claims could be, and that you understand the claims are real and that you're actually waiving. So why are the terms confidential? Both parties usually benefit from confidentiality. The employee will want to leave on terms knowing that the situation that they may have found themselves in is not going to be discussed internally and externally. And an employer will want to know that once this is resolved and the sums of money have been paid and the obligations that have been agreed between the parties, this is going to sit quietly and it's not going to damage their reputation in the marketplace or with other employees. And that's why it's important to have a confidentiality clause in there. Obviously, an employee cannot be prohibited from making a whistleblowing claim, for example. So if you're not sure about the confidentiality clause, it's really important to discuss that. What I would recommend to employers in order to save time, money and cost is to make sure that with the settlement agreement that you send to your employee, you have a covering email, and that covering email sets out and explains what those clauses are all about, so that the employee actually understands, and that will help with the negotiation and discussion process, and it will help that the advice that they get will be done relatively swiftly. If it's not clear, then a lot of time is spent going back and forth and trying to understand what those clauses mean. It's actually a really good internal exercise. So for example, if there are holidays that are outstanding that you need to pay for, set them out, set out the number of days and set out the calculation. Set out exactly what's going to happen to benefits, whether it's healthcare or a car allowance, whether or not an employee is allowed to keep any equipment, what that reference is going to say. References are really important for employees, and so they will want to understand from the get-go whether or not they're going to get a standard reference and whether that's company policy, or whether you're going to provide them with a more detailed reference. And if they're more senior, it may even be that they will have an input into what's written in that reference and they can see it. So those are the areas which I think actually take up a lot of time and effort, is not really understanding what the compensation package is, not really understanding what's going to happen with the reference, and actually whether or not there is going to be a handover required and to whom. So if those things can be dealt with, that actually saves both time and money and stress for everybody. I hope you found that helpful.